Hello! In this clip from our Justia webinar, The Power of Professionalism, Cultivating Civility in Legal Practice, Kari Sheehan discusses her final insights and thoughts, as well as answering the audience questions regarding civility in their legal practice. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
So leading by example, these are some attorneys that have gone wrong in what they've done. This first one is the case from Indiana in 2010. And remember, I told you that Indiana has had the anti-discrimination, anti-bias rule in its books for a while. This is attorney Stacey Kelly, claimed to be her husband's lawyer when she called back a telemarketer who'd been trying to reach someone by her husband's name. While on the phone with this telemarketer, she asked the representative or the telemarketer if he was gay or sweet because she thought he had a feminine sounding voice. This can lead to discrimination under 8.4G, prejudicial to administration of justice under 8.4D as in dog, because it shows bias, discrimination, or those types of characteristics of harassment too, and just being uncivilized, unprofessional. Since Miss Kelly said that she was her husband's attorney, even if she really was not, she made that declaration. She put herself in the practice of law, not just a personal capacity. She can be subject to violation of 8.4G, 8.4D, and any other rules. Miss Kelly was publicly reprimanded for this conduct. She was turned into the disciplinary commission by the telemarketer. And so we had a disciplinary commission complaint after that. This is an attorney who represented a married couple filing a construction lawsuit against a former builder. The attorney, Abrams, developed a negative opinion of the judge presiding over his client's case. Abrams referred to the judge with derogatory slurs, sexual orientation, and prejudice, saying that he thought the judge had got beat up as a child because he was very feminine, that he had no gumption or no male genitalia, different things like that. The clients, he's saying this to his client, whose case is in front of this judge, who is going to decide their case. The clients obviously did not take lightly to this. There was email evidence of the attorney doing this, verbal communications. The clients fired the attorney, hired another attorney, and turned in Mr. Abrams to the disciplinary commission. He was suspended for 3 months for his conduct for doing this and exhibiting the bias, prejudicial to administration of justice, and those different areas that unprofessionalism in 2020. So again, why are we doing this conduct? There is no room for it. There's no need for it. Why are we talking badly about a judge who's deciding our clients' cases? So we really need to check our own bias, prejudice, professionalism, and civility at the door. This is another attorney in Indiana, 2011. Mr. McCarthy represented a title company that was involved in a dispute regarding a cloud of title of property. The agent representing the seller of that property had his secretary send an email to Mr. McCarthy to arrange a meeting involved. So we have a secretary sending an email to Mr. McCarthy for her attorney, just asking to schedule a meeting. Just, when are you available? My attorney wants to talk to you. When are you available? Mr. McCarthy got this email from the secretary of the opposing counsel and responded not with his dates of availability and times of availability like a normal, decent, civilized lawyer would do. Mr. McCarthy responded by saying, I know you must do your boss's bidding and his direction, but I am here to tell you that I am neither you or his, and he used a very derogatory N-word. You do not tell me what to do, you ask. If you ever act like that again, it'll be the last time I give any thought to your existence, and your boss will have to talk to me. Do we understand each other? Supreme Court, this went all the way up, said the use of the N-word was not for historical reference, but it was derogatory insult, racist comment, prejudicial to administration of justice, showed bias, discrimination. He was acting as an attorney when he sent this email. Again, Indiana had 8.4G on the books for a very long time. And he was suspended for 30 days without automatic reinstatement. Now, that's like a death knell sentence, because without automatic reinstatement means Mr. McCarthy has to fill out an application, reapply to the bar, get accepted, go through the interviews and application process all over again before he can practice again. So it's not like he's 30 days out, then can immediately start practice on day 31. he's going to submit an application, and the bar at any time could say, no, we're not letting you back in. So without automatic reinstatement could mean full disbarment if you never get accepted back to the bar at that point. So a very death knell type of sentence for that conduct. This is one that is more recent, actually. This was in Connecticut. This was reported in Law 360, different publications. This was a lawyer who was in a deposition. She was getting very frustrated with opposing counsel, saying he'd been condescending behavior all day towards her and her client. So she grabbed the table, looked underneath it, and asked opposing counsel if he had anything between his legs. This was considered unethical behavior, unprofessionalism. And her defense, she apologized for her conduct when it was brought up in front of the court and, disciplinary things. And she said she was just lost her composure, lost that professionalism, because chronically, persistently exposed to the behavior of a condescending attorney. This is another one where we're in a mediation. A lead defense counsel decided to twerk in front of the other opposing counsel. So he bent over, put his hands on the floor, shook his rear end up and down, uttering profanities at opposing counsel, saying that maybe he liked it because of his haircut, different things like that, really digging into opposing counsel's sexual orientation or perceived sexual orientation. And this lawyer got sanctioned for it, made national news for it too, got fired by the client, got fired by his law firm. New firm that stepped in for the client, tried to get the sanctions taken away because the client and the lawyer were sanctioned. Unfortunately, described in the brief opposing the sanctions that we should put the lascivious gyrated lower flesh extremities in our rearview mirror, basically. So we may not have shouldn't have used rearview mirror in that context, but, lawyers live and learn. Judge ultimately ordered no sanctions, though, thought the attorney had suffered enough, made national attention, terminated from the case, different things like that. Texas is one of the ones that did not adopt 8.4G, that prejudice or that, anti-bias rule, but they do have 8.044, prejudicial to the administration of justice, which this could fall under at that point. We don't need to be twerking in depositions. Some other various conduct too to stay away from, obviously anything to do with race, religion, gender, just different things here. You can read those on the screen. We don't need to be calling people stupid idiots. Going back to Puerto Rico, be quiet, little girl. Don't use those shady Hebrew tricks with me. These are things that have caused disbarment, suspensions, probations, public reprimands in the past. So we really need to check and watch our conduct and be professionalism at all times. So learning from these different things, we've learned quite a lot. Civility takes a village. It really does. We have to all work together and we have to check our own conduct over and over and over again, because it is truly the foundation of our legal system, the foundation of us being lawyers, and what was being aspired to by when the codes of conduct, when we went from code of conduct to the rules of professional conduct in the 1980s, 1983. This is what is envisioned, a professional, civilized, legal community. And we are that, and we have to set that standard, and going back to that and really reinforcing it and always considering ethics and how we're conducting ourselves should be the utmost importance. This should start at law school. We should really reach law school students, educate them, not just say, hey, here's the rules, follow them, but really teach them what it means to follow the rules, really teach them what it means of how to conduct yourself. Because you can follow the rules and conduct yourself like a jerk, but still be within the rules. And so learning that professionalism and civility and cultivating it and setting the example for younger generations, middle generations, older generations, whatever generation is important. We need to break the silos. We need to train. It's not just old, new, courts, lawyers, middle. It's not older. It's not any of those things. We need to think of this as a collective, taking a CLE, speaking about it, educating within your firms, resetting those relationships and expectations, taking negativeness out, putting positive in, having that resilience that we can build it, and lead by just listening and, working together as the legal community. Social media does not help on any of this because it breeds hate sometimes and it can breed negativity. So a lot of lawyers, you probably may want to take your conduct offline. Or look at your social media policies for attorneys too. Whole other seminar though can be had on that. But again, social media has really bred incivility and unprofessionalism. And so we may want to take a look at our conduct there too. Technology is not always our friend. And so we really need to watch out for those things. And B, if you can't do it in person or wouldn't do it in person, don't do it online. Very good rule to have. Don't do it in person, don't do it online. You're no cloak and dagger when you're behind that computer screen. Always keep that in mind when it comes to it. Because it is that time to recommit to our civility, that time to recommit to our professionalism. And with that, I will turn it back over to Nina to see if there's any questions or anything that have come up.
Awesome. Thank you so much for your presentation, Kari. We can now move on to our questions. The first one is, how should one handle a situation where opposing counsel is consistently uncivil and unprofessional? What strategies can be employed to de-escalate?
In that situation, I would keep track of the different times when they are uncivil and unprofessional, either by kind of writing it down, making notes to yourself, maybe sending an email, kind of like I used in some of those slides, saying, on this date, this happened. I'm just documenting it. This is all I asked for. This is the conduct. And then eventually, when you have all of that, kind of mounted up, you can pose it for a motion for sanctions with the judge. And on top of that, potentially turn it into the disciplinary commission against that attorney and have the disciplinary commission investigate it. We are that self-reporting or like regulation of lawyers, 8.3. So if you know they're violating being uncivil and unprofessional, then you probably may reach that standard of needing to turn it into disciplinary commission, but you can also move for that motion for sanctions too. But make sure you write down, document, even if it's a memo to yourself, an email to them saying, I asked for this, you did this, or whatever the situation may be at that point. And then always check your own conduct. Don't go to their level. You need to keep yourself civil and professional. So, yep.
Great advice. The next one is, how can law firms promote a culture of civility among their lawyers and staff? Are there policies or training programs that are most effective in achieving this?
Sometimes in law firms, it's lead by example and not putting up with incivility. So if you have some lawyers who are constantly berating or constantly being uncivil, then taking swift action of discipline and making sure that it's fair across the board. You can't show favoritism. You can't, it only applies to these, but they've been here forever. They're a rainmaker. These rules don't apply to them. They can act how they want. You can't have that. Otherwise, you are going to breed the incivility in the firm because everyone's going to feel they're not going to be treated fairly. And then holding internal seminars and CLEs within the firm, you can do that too. Having your leaders speak out on civility and what they expect of the lawyers, saying your managing partner or the main partners of the firm. And then their conduct. It's going to start with the top down and the fairness that comes from that. Policies can be, don't use profanity in emails, don't yell at employees, open door policies, different things like that. There's not a one size fits all depending on your firm. But you've just got to exhibit it by behavior first and then really look to your own conduct too. Because if I'm a young lawyer and I see the partners behaving badly or that attitude, I'm going to adopt that attitude because I think that's what I need to get ahead. And so everyone across the board has to adopt this civility.
Thank you. Our next question is, can you discuss the role of civility in client relationships and how it affects client satisfaction and trust?
Civil with our clients, it really does affect the trust and satisfaction because the more civil you are with them, the more they're going to trust you. If you think about like any relationship, if you're constantly, say, yelling at your significant other, spouse, or kids, they're not going to trust you. They're going to start shutting down. They're going to fear you and not respect you. But if you're civil with them and professional with them and are open and honest with them, even when it's hard, you're going to build that relationship of trust. And then they're probably going to be more open with you. They're probably going to feel more comfortable with you and probably take your advice more. Because a lot of clients, if they shut down and don't respect you as a lawyer, they're not going to take your advice. They're going to fight against you, even though they still have you as their lawyer. So having that civility with them, communicating in a way they understand and in a demeanor they understand, and tailoring your conduct to their needs is important. I know I've been told in the past I can come across as very blunt sometimes, especially when I'm really in a hurry and just want to get the information out. But I always have to stop and think, does this client need more hand-holding? Does this client need a longer explanation and not just a blunt yes or no? And so really tailoring my communication can help build that trust too.
Thank you. I think we have time for a couple more questions. So there's one here that says, when an attorney threatens a civility bar complaint due to a polite disagreement, is that accurately called abuse of the legal process or prejudicial to administration of justice?
Could be both, depending on the situation. We should never threaten anything as lawyers, and that is prejudicial to the administration of justice because we cannot abuse the system. You don't threaten lawsuits, you don't threaten things, you don't, say, I'm going to sue you if you don't do X, Y, Z. We can't do that as lawyers. And so, if there is a lawyer out there doing it, they probably are abuse of the system, which could fall under prejudicial to administration of justice. And that's conduct that is a bullying type of behavior. And so that is probably going to violate incivility or civility and professionalism at that. So in those situations, depending on how extreme it is or the context of it, because every situation is different, you may consider talking with the disciplinary commission. A lot of states and jurisdictions have hotlines, so you can call and kind of give them a general scenario, and they can tell you how best to proceed. And you can do that under confidence and everything like that. So that may be an option for you if you have that in your jurisdiction. Or you can just always file a complaint, and if the disciplinary commission decides to investigate it, then they can take it from there. And so,
Thank you. And then I think the last question we have time for today, do you have any practical steps or tips and tricks for lawyers to maintain civility in their daily lives if they're feeling stressed or if they come across a contentious situation? What advice would you give?
always say stop and breathe. If you are in a contentious situation or get a contentious email, don't respond right away. There is no pressure to respond within that exact second, whether it be an email, a communication. I always like to use the phrase, let me think about that, I'll get back to you. That usually means one, I don't know the full answer. Two, you just made me mad and I can step away and calm down and then come back to you with a reasoned, thought out answer. And maybe my being mad or being triggered or something was an inappropriate response. And so I've got to really think and assess, or maybe I'm just in a bad mood and I know it's hitting me the wrong way that day. And so just kind of step away. And you can always say stuff like that. Well, let me get back to you. Well, I've got 10 things in front of you. I'll think about this evening. I'll get back to you tomorrow. There's nothing that says we have to respond right away as lawyers. We have to do it in a reasonable prompt time, but that doesn't mean the exact same second that you read it or hear the communication. And so, and then taking breathing, I know when I was an early lawyer, I started practicing yoga. And for some reason that calmed me and I made it like a meeting every day. I put it on my calendar at 5:30 every day. I do yoga, or 7 o'clock. I do yoga. And if someone tried to block something in that time, I'd be like, "I'm sorry, I have a meeting." And I wouldn't call it a workout. I'd just say, "I have a meeting." And that was just always on my calendar to have that de-stress moment, to center myself again and to come back fresh for what I needed to do. So.
Thank you. Those are all such great tips. We really appreciate you taking the time to answer our audience questions. And thank you all for submitting your questions. We want to thank you for joining us for another Justio webinar. Thanks for watching. We hope you enjoyed this video. And if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.